Good evening, ladies and gentlemen, and welcome to the Bunker Show, coming to you live and direct from our bunker here beneath the sewers of the Old Bailey with another legally based Adventures in Legalland UK show. We've got three great guests with a lot of court experience today, but before we meet them, a little catch up with our bunker crew. Here with us on comms, here's Helen.
Evening everyone, hope you enjoyed tonight's show. It should be a good one. Don't forget to join me in the chat room for interacting with the show, asking our guests questions, any feedback you might want to give.
And also joining us in the bunker today is Jimmy.
As always, a pleasure to be here with you and Helen and Fab. And, you know, despite the pong of the Westminster sewerage, you know, I wouldn't be anywhere else.
Well, our Westminster bunker is closed for repairs because, accordingly, they've had a storming stampede of celebrating socialists, which has put seismic stresses on our subterranean sanctuary there beneath the sewers of Westminster. So it should be ready and fit for us next week. But we are going to have a little bit of a look at some of the spin that has been around this week. And you've been looking at an interview Dennis Skinner had with Emily Maitlis of the BBC.
Yeah, that was, I noticed that earlier during the week. And it was quite interesting because, you know, like if you followed, you know, the Jeremy Corbyn election result and the post-Jeremy Corbyn election result media coverage, there's, you know, at best you could call a hatchet job that's being engaged in by, you know, like all the various media outlets. And, you know, quite noticeably the BBC, you know, like despite all claims of impartiality, there definitely seems to be quite a slant. And what was interesting the other day, Emily Maitlis was caught out in the most horrific way when you think about it, because what she was describing as a joke, you know, and I'm quoting a joke, was essentially contorting her interviewee, Dennis Skinner's statements into a complete fabrication, you know, essentially spin. But, you know, in essence, a lie. And this is what was being passed over as news, you know, not a joke. What do you think, Fab?
It's interesting to see how Dennis Skinner, who's held a position consistently since the mid-70s, when it was thought that he might be asked to be a minister in Jimmy Callaghan's government, very clearly stated that he wasn't interested in patronage, so he was going to effectively not accept any ministerial positions in any government, as he works most effectively as an MP.
He made it quite clear during the interview that was his position, and, you know, that was quite clear, I think, to the audience too. But at the end of the interview, during Maitlis's roundup of the story, she provided a nice little bit of spin to add a little bit of contention to the story where no contention existed. And Dennis Skinner, interestingly enough, appeared back on air. No, basically, you know, curmudgeonly, he kind of like ran back into the interview and just said, "Oi, you know, like, what was this about? You know, no more spin. You know, like, this was ridiculous. It was just a blatant case of the BBC being caught out on air."
And by way of apology or by way of an excuse, she attempted to call it a joke. Now, also, Jeremy Corbyn was in Parliament today at Prime Minister's Question Time, where he, I guess, played a bit of a joke on David Cameron, because at David Cameron's first Prime Minister's questions opposite Blair, he was saying that he wished to engage in a new adult type of Prime Minister's questions, where questions would be asked, reasonable questions that are pertinent to the public, and they would be answered in an adult fashion. It's open to debate how long that lasted for Prime Minister's Question Time, but from the BBC using spin, it'll be interesting to see if Prime Minister's Question Time becomes more adult and less spin, and we actually get serious answers to serious questions. Because in the case of Jeremy Corbyn, there have been some serious questions put forward, none least by the Member of Parliament, John Mann.
Yeah, I've been taking a little look at John Mann's open letter. He's the Labour MP for Bassetlaw, and he wrote an open letter to Jeremy Corbyn on the 23rd of July this year, accusing him of doing nothing to prevent the abuse that happened in Islington while he was MP there. I'm highlighting the Dickens report from 1986.
And so that's almost 20 years ago, and Jeremy Corbyn, that's his own constituent. So he was being approached in 1986 by constituents raising concerns to him.
Yeah, well, I'm interested because in the response to John Mann's letter from the Corbyn camp in July, which was that Jeremy Corbyn has a long record of standing up for his constituents. He called for an independent inquiry into child abuse in Islington at the time and has taken the strong line ever since. My question is that the case from the evidence that we have?
I was just going to say, because I believe that Geoffrey Dickens at the time was taking up a number of cases that he didn't feel were getting attention back in the mid-1980s. And was Jeremy Corbyn supportive of Geoffrey Dickens in that?
No, when Geoffrey Dickens broke the story about the Islington area, Jeremy Corbyn actually had put in a complaint about him, and I have the article here from the Times on February the 19th, 1986. Jeremy Corbyn, Labour MP, demanded the Commons that Mr Geoffrey Dickens should go to the Holbrook estate in North Islington, unreservedly withdraw his allegations of the existence of child brothels in the area and make a public apology. Mr Corbyn said Mr Dickens misled people and criticised him for irresponsibility, passing unfounded allegations to the media, which has caused a great deal of hardship and hurt to the people of the area. So I'd say he was wholly unsupportive of Dickens' actions at the time.
Now, it took a long time for the Islington the Islington Council, the child protection bodies, I guess even the Ministry of Health, which had authority allegedly over these young people, led at the time by, I think, Virginia Bottomley. It took a number of years before there was any more action. So
I followed it through, and in 1992, 4 current or very recent employees of Islington Council, whose jobs were to safeguard the poorest and most vulnerable children in the area, visited Jeremy Corbyn to tell him that they'd recently come to the conclusion that organised child abuse was occurring across Islington on an alarming scale. Jeremy Corbyn listened to them. He was supportive towards them and told them that he would take it up with Virginia Bottomley, but there is no record of anything further going on, and he never contacted them again, according to Liz Davis, who was one of the social workers that was present at that meeting.
And she's been quite prolific in getting some form of investigation that was able to show that there was there were serious issues in Islington, and definitely with the way that situation was managed. Because there
in
was...
August that year, a survivor of abuse in an Islington child home visited Jeremy Corbyn and told him of some of his experience, and he reports to be being dismayed over the ensuing years by what he regards as Corbyn's silence on this scandal, and his story wasn't taken up. And also that's backed up by Eileen Fairweather, the journalist who broke the news on the Islington scandal in the Evening Standard in October 1992, who visited Corbyn, spoke to him about the seriousness of child abuse, shared detailed evidence about the borough's children, how the borough's children were suffering, and she said the MP listened politely but never wrote or called after the meeting to thank her and responded to her claims with inaction. So it sounds, like there are some questions there that do need to be answered.
So for Jeremy Corbyn in his current position, with Tom Watson, a man who has broken parliamentary establishment to raise the question of a paedophile ring surrounding Number 10 and Westminster, and now that has been evidenced, it's very clear that a lot of those questions still stand, and that people are responsive to members of Parliament like John Mann, who are asking very, very serious questions in relation to that, in relation to the Official Secrets Act, which is not meant to be used to cover up child abuse.
Yeah, I mean, one thing I was going to ask you guys, do you feel it's quite bizarre, for Corbyn, who has been really vocal and, is apparently quite unafraid to tackle contentious issues? Don't you think it's bizarre? It's almost, a glaring omission that he's remained silent on the topic of institutionalised child abuse.
But to a certain degree, during the Labour Party leadership, child abuse is not generally considered a party political issue, even though it's something that a huge amount of the general public are very, very keen for all political parties to grab hold of and bring to some kind of resolution. And what was the case in Islington with?
On May the 30th, 1995, there was an independent article reporting that the Labour Borough of Islington has finally put its hands up last week. Last week, an independent report confirmed that pimps, paedophiles and pornographers had for years preyed on children in Islington homes. The report highlights the inaction of the council and notes that some social workers met Islington Labour MP Jeremy Corbyn, begging him to influence the council, who were then still denying everything. Soon after, the reporter met with him, and apparently he states that Jeremy Corbyn made inquiries but was with the council, but was reassured, and that the matter rested there.
So we're going to be keeping an eye out for more thoroughness from the Labour front bench to get some movement on that. And on the subject of responsiveness, we recently had, we discussed on the Bunker Show, magistrates resigning due to the changes in legal aid and more specifically the fixed court charges that are now being charged. Well, in the intervening weeks, that number has now gone up to over 50 magistrates who have resigned, and there's an ever-growing call for the government to review that decision and that piece of legislation after 6 months to see what the real practical impact of that fining regime on members of the public. Even though the government are still insisting that a 3-year period would be suitable. We have with us today for our legal show, as always, Vin James. Vin, are you with us?
Yeah, I'm here, mate. Thanks for having me back on the show again. Hello, everyone.
What do you think about the fact that the number of magistrates resigning at the court charges is now over 50?
Is that all? Ain't enough, is it? It's... I really don't know what to make of it. I mean, there's enough coming through the system to replace them anyway, in a sense of, they're probably bringing in people who are more easily sycophantic to the system and that. I think the thing is with a lot of these older judges, they come from a slightly different generation, especially from the 60s, a lot of them came from, where, there was a bit more... The culture at the time was a bit more rebellious against the system. Whereas I think now a lot of the judges that are coming through now to basically replace a lot of these people are a lot more hopelessly stuck in the system in that respect, stuck in the religion. Whereas maybe some of these older judges and that were maybe exercised a little bit more independent thought. You know what I mean? So.
Yeah, it's interesting to wonder how many of the upstanding judges, magistrates, the ones who are able to listen and have integrity, to realise that actually fining anybody under any circumstances is, if they can't afford it, is an unjust thing to do. And I think a lot of the magistrates are becoming aware of that. We also have with us again Bradley Knight. Bradley, are you with us?
Yeah, I'm here. Sorry, I'm still playing with this mic issue.
Hey, well, you're coming through loud and clear.
Yeah. I know. Good afternoon, evening.
Hey, well, we were just discussing how many magistrates have recently resigned over the new court charges, and people who aren't that wealthy being affected by them.
Yep.
Do you have any thoughts on that particular issue?
I think it's awesome. I think, like Vincent said, there should be more resigning. But the problem is, it's like cattle, really, in some respects. There's a nice lineup behind them. So, you know, the impact is not going to be that much. I mean, 50, because bear in mind the rotation in terms of magistrates, because it's all civilian, the numbers are massive, absolutely massive. So 50 is hardly any. However, it is a reasonable number. But saying that, some of them would probably just wanted to retire anyway. So, you know, I mean, my view is a good thing that there's some people in the system that are basically protesting, and these people do have powers. These powers. So I think it's a good thing. I think what impact the number of 50 will have? Zilch. But, you know, who knows?
But do you think it's quite a strong statement that people of the standing of magistrates are saying that they feel that strongly that they don't know if they can continue? Do you think that shows a certain lack of faith in the current direction of the judicial system?
My honest opinion is, based on the magistrates and judges that I speak to, and barristers and solicitors, none of them like the system. None of them. But basically, the generic response I get, but that's the system that we live under. None of them like it. I've never had one meeting with a judge, barrister, solicitor, or magistrate where they basically said, oh, this is cracking stuff, this is. We're getting people off the streets, we're sorting them all out, we're making good for the world. I've never once had that. Never once. What the common response that I get is, effectively, it's a system and society we live in. That's it.
So it's the best that we've got so far.
Yeah, I guess so, yeah.
Well, in that way, I mean, that sounds a little bit like damage control to me, and that's a term that often comes up in legal circles, because when you get that letter that comes through your door that says you have an issue and that it could progress to a legal forum, that's quite a bit of an impact. And people often want to engage in damage control to make that impact as minimal as possible. So have you sort of found in practical experience the use of, I guess, damage control, and really how to avoid conflicts that could escalate legally?
Okay, fine. Okay. As I've always said, and my audios cover this quite well, is my preference is not to be in court. However, the way I conduct my lifestyle, and indeed other people's lifestyle, or the people in the group, is essentially what we try and do is damage limitation, if it has to get to that stage, or basically wipe it out, get rid of the situation. A lot of it's down to lifestyle and control and how your conduct is. To use the word controversy, let's just use that word because it's a common word used. The way that we try to approach the audios, for example, is to get people set up to just think about the actions, think about the causes and consequence, and as soon as you get some sniff of there's potentially a problem coming, prepare for court. Now, most cases will not go to court, but you prepare for court. So all your correspondence, all your communications, all your diary notes are all recorded. Because you're not going to lose anything by doing that. You know, if you write a letter, send an email, print it off, stick it in your file. Because as soon as you get that first notice, so for example, Fabrice, if I want to set you up, I'm going to do a very soft, cleverly worded letter. Not the big red letters that you get from all these bailiffs and all that sort of crap. But basically, if it was me to you, I would slowly set you up for you going to court. Now, you may not see it initially. Now, what other people do as well, bear in mind, these corporations, this is their business and their life. Now, they do it a bit more direct and a bit more forceful. But as soon as you get that first correspondence, you need to start working as if you're going to court. You need to be clever. You need to be unresponsive. Now, that doesn't mean don't reply. You should never not reply. You should never not reply. And you need to be skillful in your responses. Like, for example, I'm babbling on a bit here now. I've seen many letters through people that contact us. I mean, we're like literally last stop normally in the car park where people have just tried all sorts of crap. Vin's just handed us a lovely case at the moment, which is which is one of those fine examples of Freeman-esque type attitude, where they've sent loads of crap,
last week we had Gary Capps on, who was very, very clear about not taking a position and asking for more clarification on exactly what the cause and nature of any particular proceeding is. And I find it interesting that when you said when you first receive a letter that if you at that point construct a chronology, then it gives you that structure that can be very, very useful should you have to explain your case later on in court. And often people hire solicitors for those things if they have faith in them. But a number of people don't even have that choice these days. So in terms of having people who are contacting you and Vin and myself and others in looking at more options that are available to them.
I mean, one thing, Fabrice, one thing that is very evident from my experience, which goes back some way, is here's an example. We're complete strangers to these people. We're not legal counsel. What we do is try and help them through the system and get them out of the crap they're in, because they wouldn't be calling us otherwise. Now, an often expression that I get is I say to them, well, what letters have you written? Well, I wrote a letter on the September. No, it's not September. It could have been January. Whatever. All right. And I say, okay, fine. Right. So you wrote a letter. Can I have a copy? I'll get you a copy. Okay. Christmas comes and still not got a copy. Now that's slightly exaggerated, but what I'm saying is, emails, telephone call records. Obviously, faxes are not really used nowadays, but any form of correspondence is important to record. Make notes when you're in court. I was in court recently on the infamous Tom Crawford case, and his legal team, not one of them were making notes. Not one of them. So free, lazy efforts.
What's the value of recording correspondence and making notes when you are in court? And maybe even going the extra step of double checking what notes were taken in court. If it's not a magistrate's court, it's not a full court of record. So what notes are actually taken can often be quite important too.
Fabrice, even if you win the case, it's important. I mean, we've got another case at the moment which Dean's dealing with, where they won the first case and they're going back again to attack him again. This is a local authority to do with a ridiculous planning issue. Oh, this is actually Vin's case, actually.
Oh, okay.
Yeah. Not you personally, but the one you sent to Dean.
I don't know if Dean got involved in it. I know you did, and a few other friends, but I think Dean knows a little bit about it if he wants to jump in and.
Well, Dean's not actually connected at the moment. We're having a few technical issues getting Dean on the line, which hopefully we can resolve.
But anyway, that was just an example, yeah. So the note taking. I mean, like I said, we were talking whenever it was when we had that stupid guy on, who was quite rude, badder guy. We were talking about. People coming in groups into court and all that sort of stuff, right?
Yeah, court support and the value of that. So, how many people and what kind of people, what kind of... because sometimes you were saying sometimes you prefer to have fewer people in court because sometimes it can make you a bit nervous. Sometimes
I said that. I didn't say that.
No, I don't think that was you.
Oh, right.
But I've heard some people say that they don't like too many people in there because it can make them nervous. Oh, right. Whereas sometimes you can have that many people in court that it can become disruptive. So to get the right amount of people so that people are on their best behaviour. Yeah,
but what you want, though, right? Just going back, I don't want to make this into the Tom Crawford show, but basically, I went and witnessed this court hearing, which was a complete joke. I'm not joking. I've never seen anything like it, right? Anyway, I'm thinking you've got Ebert there, you've got John Hurst, you've got two other people, all of them just sitting there, and you've also got Tom Crawford, and not one of them are making notes. Unless they've got a tape recorder or willing to order a transcript, how are they going to know what was actually said? It's so important. It's so important. Now, I agree with you. For a layman, it's important to have some support. It is. Everybody wants a bit of support and a cuddle. I understand that. Now, obviously...
Yeah, I'd just like to jump in and say, for me, it was absolutely vital, and I always had note takers, a media rep, Mackenzie friends, so that I had support all the time. I wouldn't have been able to do it otherwise.
Yeah. No, I agree, Helen. I mean, it was really vital. I mean, most people don't go to court to the scale that I go to court, right? So, and most people may not even go to court in their entire lifetime. And the whole process is frightening. I was saying to someone yesterday, I think it was yesterday, or possibly today, that I've had the smartest guys, like company directors, that employ 60, 70 staff, confident as hell, literally walking in the courtroom, and that's it, they fail, flop. They literally limp. The actual better, let's call it victims, that go into court are the ones that basically don't have a clue what the hell they're doing, and they act so innocent. And basically, the magistrate does the work for them, or the judge does the work for them, and say, "Do you understand this? Do you understand that? How about this? How about that?" It really is. There's an art to it. The problem is, a lot of people go in so clever, and they don't know what the. I mean, a prime example.
One thing we spoke about last week, Brad, was. When people go into court and they become reactionary. I mean, one thing again, you said it in earlier in the show in terms of paperwork, of not being reactionary, but being considered in how you reply to that paperwork and the level with which you wish to respond or not. So how if you go into court and you're not able to keep that cool, then it can mount the pressure to upon you, so that it makes it harder to think clearly about your case.
Yeah, I mean, I think probably if I put it in percentage terms, 40% of the work, let's call it work, that we do. Is basically where I'm in court myself with the party involved. 60% is Lincoln in-person training. So we're prepping them for court, staging it up, and our success rate is huge. I mean, I've got some awesome cases that we're going to be posting about only from the last couple of weeks. Unfortunately, I had one of them I left out in the rain, and the other one I've blocked, which I think means that I have to wipe it now. So I've lost a bunch load, but anyway, I've still got all the contact details. But yeah, it's about slowing things down, being considered. I mean, there is a skill to it, but it does take time. But some people. I had a guy from Croydon we're now, unfortunately, he's getting ambushed. He's got 5 cases plus an eviction. He now, on his own accord, has got rid of 4 of those charges using, our guidance. 4. So we've only got the eviction to deal with now. So 2 of them were drug offences. 1 was an ASBO issue. I can't remember what the other one was. But we've got rid of all 4 by him following and being extremely aggressive towards the CPS. I mean, he has been to court quite a lot of times, to be fair, but we hit them on disclosure on every single case. I mean, his son was being attacked as well. His son's got an ASBO, which is until December. But, he's worked he's had to work really hard. But the good thing about it is he's followed the guidance that we've given to the T, apart from one where he started. I think he was getting overconfident.
I mean, you have to focus and know what you're doing. And, in terms of, you mentioned role play and preparing people for court so that they know effectively or have a clear idea of how they would like their case to proceed.
I'll give you a prime example, Fabrice. Do you mind me putting a swear word in?
No, if it's appropriate, go.
Okay, right, okay.
No censorship
this guy specifically, he phoned me up. This is one of the court hearings. He phoned me up and he said, this is going really well. This judge is right, looking after me. He's going to sort me out. He said he just wants me to go and get some paperwork and come back. And he was explaining about how the hearing went. I said, that judge is stitching you up, mate. I said, don't listen to what he's saying. You've got to be very, very careful. Anyway, 3 hearings later that same day, that judge is right fucking wanker. That's what he said. But the thing is, what you don't realise is that you've got to read into what they're actually saying. So, like, for example, I've done cases where people, where I've been a Mackenzie friend, where I've not got rights of audience, but I'm sitting next to them, and I'm like clicking my fingers at a person's face that's sitting right next to me. I said, don't worry what's going on over there. Just look at the expression of what the judge is thinking and seeing. And then what the prosecutor's saying, I said, I know what he's going to... Well, obviously I wouldn't know verbatim because I didn't know what he was going to say. But I said, I know what's coming. And exactly what was coming, come. But she ultimately, she got some relief. Not as much as she wanted. But you've just got to really listen to what's going on. And it's easy to get prick teased in court. I mean, Vince suffered it quite a few times.
In terms of, you mean by distraction?
Distraction, yeah.
Okay, yeah, because that in that way, that's quite a common thing. Actually, it's probably a good time to get Vin's opinion on.
Just one thing before that. One thing I will say: I never take offence to anything that's said in court. No, never ever. Right, and that's really important skill to learn. Because what happens is, if, for example, you hear a voice that's something you don't like, you end up piping up. You never want to do that. All you want to do is make a note on your paper that's something you want to sort out once that person's finished talking. Okay, Vin, I'll leave you.
Sorry, mate, go on.
I was just going to say that's a really, really very good idea, is to make notes of exactly what you'd like to say, when you'd like to say it, and just be patient. Because it stops them taking the initiative. And in terms of the court costs, it can be very, very hard if people are financially hard pressed when you have a magistrate saying to you, if this does proceed further in any way, this could land you with a large amount of money on top of any fine that goes forward. It can be that intimidating that you might just go, do you know what? If I go yes now I just have to pay couple of hundred quid and it's gone. So, that can be quite an intimidating experience in a number of ways, which is maybe why some of these magistrates are resigning, as that's becoming, more obvious. Vin, what do you think about the ways in which people can feel under pressure from the bench and the court process if they haven't been through it before?
Well, I think we mentioned this before. It's before you, if you've got time to actually do it beforehand, actually go into a couple of courtrooms and sit and watch and get a feel for it, because without that, you're going to be going in blind and you're just going to let your imagination run riot and let yourself get wound up. It's best to try and put yourself. They're not. I mean, they're not the most pleasant places to be in, and depending on what case you might end up hearing, might not be the nicest thing in the world to do. But that's the thing. Get yourself familiarised with these courts and around these people, and it is just a matter of when you're learning something and you're preparing yourself for something, just break it down into the parts and understand the most important elements of those parts that you've got to learn first. So when we're teaching people about critical thinking skills and things like that, it's those 5 W's. Just those are the key elements for you understanding anything. And once you've grasped that, and that's how you can better prepare yourself. That's really going to help. And it's not to put too much pressure on yourself. At the end of the day, the more you can use your own common reason, the better it's gonna help you. So that will give you the confidence as well. And I mean, the thing is with what we do with these groups is we do help people get prepared for court mostly on their own, because a lot of the time we can't always be there with them or help them out as Mackenzie friends. But even if you've got someone with you who's not been part of this group and they're not as experienced as being a Mackenzie friend, still having just somebody there with you is really going to help and help with your boost. And like you say, it's all about taking notes as best you can, and just try and take as much from it as you can. I think the thing is obviously when you go into court, you've got I suppose the attitude I'll take is I expect to get screwed over. I know these people ain't going to want to listen to reason, and they're going to find any which way they can to convict you or whatever anyway. So
yeah, no, I disagree.
Well, I'm just saying that's the attitude I'll take. If it goes the other way, great. I'm more than happy. But I always take this view that they're more likely to screw you over anyway. So don't go building your hopes up in believing that you've got the strongest case in the world, and you think that's it. I'm gonna beat them up here, and they're gonna have to bow to me. It doesn't work that way in the real world. And I think it's a matter of you're trying to set a platform. You're trying to set a stage for, if it does have to go to appeal, at least do your best to get it to that point if you can.
I think it's interesting to see how much of that balance changes between what I guess we would call less serious offences like speeding and parking, and I guess offences that get heard at magistrates where there isn't custodial sentences, to some of the more serious offences where it does seem that more time and resources are being put in. Whether it's enough, I don't know, but that's my thoughts on the issue. And Bradley, you had a slightly different take.
Yeah. My take is pretty simplistic in some respects. Is that, and it goes back to what I said just earlier on in the call. Is that in the recording? Sorry, is that prepare for court? I mean, I just can't say it enough. I mean, I've lost cases. I have. I've been like an example would be, because I try to hang around the High Court. To be honest, the reason being, I think you get a better standard of judge. Now, I've had judges basically, tell effectively I lost the case, but it's an interim loss. So basically, what I do is, like Vin just rightly said, is I build a case on the basis that I'm going to appeal. So that's a second tier. But the problem is, if you try and train people in that in that stance, it's very difficult. For example, what I always do with the people that we work with in the group, and the other group members do as well, is because most of the people we deal with are vulnerable people. None of them are rich people by any stretch of the imagination. And they're like stressed out, end of the road, they're stuffed. Some of them are losing their houses, some of them are losing their wives, some of them are losing their cars, all that sort of stuff. But what I do is say, okay, this is the situation that we're in, and I would have already set up in my mind the end goal of what's likely to come out of this situation. So, because we don't like working with people that are lazy for themselves, right? We do a lot of work for people if we have to. But what we do is get them to do it. The reason why we get them to do it is because it builds their skills and their confidence and knowledge to know what they're doing. So what we try and do is say, look, focus on this task. And then they go away. But what will happen is, as well, in between that bit, they will say, oh yeah, but what about we do this, and what about we do that, and next week I'll do this, and all that. No. Focus on this task.
Yeah. Hi, Bradley.
As Sandra said yesterday on one of the audios, take the ladder one step at a time, and we'll get you to the top to the best of our ability, which comes to mitigation at worst case, or comes to a win or success, if you want to call it that. Sorry, Jimmy.
No, hey mate, it's nice to hear from you again.
Yep.
I was just going to say, like having seen Fabrice in court and actually having seen, hung around Helen for a bit now. One of the things that I can remember, and this is from personal experience, that really built my confidence actually in the courtroom, and this is something that Fabrice hammered into me right from the start, was keeping your courtroom bundles tight, like making sure it's all kind of like everything's there, and exactly what you're saying, being familiar with there within.
And I think we've got Dean just being able to join us, and I know that Dean's been helping Brad with some of the cases that you've got going. Are you with us, Dean? Well, we'll try again and see if we can get Dean on. Bradley, you're about to say about the bundles in terms of making sure they're paginated and clear.
Oh, yeah, I'm not too sure if Jimmy finished what he was saying.
No, that's practically what I was saying.
Yeah. So basically, the bundle is actually is actually quite messed up. Sorry, not messed up. Sorry, excuse me. I was thinking about Dean. To make sure your bundle's paginated. I'm guessing you guys know what that means, right?
Yeah, but give it a run through for the listeners.
Well, basically indexed, numbered.
So you have each section with a number and a letter, so that it clearly defines where it is and which element of the case that it's dealing with.
Okay.
And I was going to say, when you have your paperwork very, very clearly laid out like that, do you find that again makes it increases the confidence that people have when they do go into a courtroom?
It makes your life so much easier, and also the judge's life is so much easier. Okay, Dean looks like he's here now. Dean, you here? No. Okay, fine. It makes your life so much easier. Now, something else that we cover quite a lot in my videos, although it may not come across quite clear all the time, is find the narrative and find the holding, the bits that you want to focus on. It's so important. And what I would do before going to court is put a post-it note in the relevant sections. Now, the main thing you want to rely on, this is what I do, is basically some of it's not going to be relevant to case. You're trying to beef it up a little bit, yeah? So what I do is get a highlighter pen to specific sections that I want to focus on. And then as soon as the other party mentions something, and obviously this is kind of civil, but actually I want to talk about this in a set, actually. And I highlight all the relevant sections that I think are pertinent, right? Key issues. On the other side's bundle, key issues, post-it note the whole lot. And it really helps you understand your case, because that basically gives you a premise and understanding that you've read it. Because if you don't read your documents properly, you could be setting yourself up for fail. I know it's a common word. Now, going back to criminal, so magistrates court, something that I mentioned before, probably not with yourselves, but I may have, is the issuance of a skeleton argument in magistrates. Nobody does it. It's hardly ever done, but I do it all the time.
And does it must be, thinking about it from a magistrate's point of view, a useful aid to them if it's clearly laid out.
They find it interesting. They really do. I mean, what I try and do, to be fair, magistrates, because I'm sure they're nice people, but their egos are massive. Judges have egos, but to a manageable scale. It's however they do see it as their courtroom, their city, that sort of stuff, and they do have a lot of authority. But magistrates, they actually enjoy a decent case because all they're doing is farming all the time.
And I was going to say, Bradley, I think Dean is with us now. Are you here, Dean?
Gosh.
Hello. No, okay. It seems like because Dean's been helping you a lot with the construction of those.
Well, basically, the way we work and have been working, it's probably for the last. I've been doing this now for just over 10 years. For the last 7 years, I've started establishing people that I know and trust that could help me, because slowly, we've ended up in a position where our services, which is completely charitable at the moment, I keep on getting interference from Dean, so I'm not too sure if he's there. But anyway, and now we're to a group of 20 of people I know and trust. It's like a family. The amount of people.
And so you're able to have with the people there, people who are able to run through in terms of role playing, having a look over paperwork, and I guess talking through some of the nerves that people may have.
Yeah,
we're moving into the home stretch now at the show, Brad. You mentioned PIN notices. Would you be able to say a few words on those?
Yeah. People should be very, very concerned about them. I only found out about them, I think it was January this year. I've never even heard of them before. It's called police information notices. It's effectively a form that the police have generated as a form of a notice without any investigation whatsoever, and are asking people to sign them to tell them to stop doing something. So, for example, harassment or whatever.
And they're relatively new, aren't they? They've only been around for I think a few months, or maybe a year or so.
No, it's been a couple of years.
About a couple of years.
Yeah, so they're still relatively new in some respects, but it was constructed by the police force, and they saw it as an easy way of just slapping someone's wrist. But they issue them like confetti. Now, Parliament have said they've got no legal standing, because what happened was, I'll be as short as I can. My daughter's in a group of friends. One evening, one of the daughters fell out with one of the other kids. 3 other kids. And effectively, what happened was, she reported it as a harassment to the police. Her mum did. Police went round the house with no investigation whatsoever of these 2 daughters' houses, and issued in these PIN notices. Now, they're friends of Tracy's, basically, and so they said, we've signed these notices, but what is it all about? Anyway, I've never heard of them, so I thought I'd start investigating. So basically, these PIN notices have no lawful standing. However, when I started investigating, it only took me a day, just doing a few Google searches, not a whole day, obviously, but, over a day. The Google searches, that actually the police are using these in court, these documents. So these 2 14-year-olds have been issued PIN notices. It's going to stay in the police custody for 7 years. Now,
wow.
one thing that's there's a court case. There's only one that I could find where this has been challenged and successfully challenged in the High Court. Where basically that person managed to get their PIN notice removed. Now, what the police will say, and this is how disgusting they are, right? What the police will say, well, there's no legal standing; it just sits on your file. Yet they are putting them into court. I've got a police officer.
So they're effectively rumour notices if they haven't been fully investigated.
They're never investigated.
Sit on your file for 7 years, and effectively be prejudicial should anybody engage with that file. So that's that's quite an interesting thing to be aware of, and obviously
you should never sign them. Do not sign them. You've got no lawful obligation to sign them. But the problem is with these two young girls. Do you know what the police did? They said they're not going to remove them, but what we'll do, we'll put you on some training courses at the police force, and as a sweetener. And I said, well, take the sweetener if they want it, but you still got to get them off the file. I said, it's just absurd. I mean, quite a famous guy at the moment that you guys will probably all know in this freedom type movement is Guy Taylor's just been issued with a PIN notice. So
that again?
Go on. I said Guy Taylor has just been issued with a PIN notice for harassing a solicitor.
Really?
Yeah, without any evidence.
And that's dangerous if you can start having tools like that are definitely not transparent, because at least in the case of a warrant, allegedly, there's supposed to be an application which is supposed to meet certain criteria, which obviously PIN notices don't.
Hello?
We're almost running through to the end of our hour in the bunker.
You've got Dean, I think.
So I'd just like to say thank you very much, Bradley, for taking some time this evening to join us in the bunker.
Yep. No worries.
And Vin, I was going to say, as always, thank you very much for your input.
That's all right, mate. Thanks again for having me back on. All goes too quick this hour.
We'll have to see if we can find some more time on Dark City Radio to do a few more, or maybe a few roundtable specials. If we've got... sorry, who else have we got here in the bunker to say goodbye? We've got Jimmy and Helen.
Yeah, good night. Goodbye, everyone. Thanks for joining the show. Shame we couldn't get Dean on, but we will have Dean Kirby will be on another day as a guest, because we've had some technical gremlins getting him on.
Yeah, and cheers, guys, for coming on. And yeah, hey, Vin, at some point we've got to continue that chat, man, because I just love talking to you, dude.
Thanks for coming here. Cheers.
And if you're after some more interesting entertainment this evening on Dark City Cannabis Compassion Club, they've got a really interesting story about a child with epilepsy and how cannabis has made some real difference to bring that condition under control, and some effective use of the medicinal properties. And on that theme, Captain Max Steele has a practicing shaman from Colorado who's been able to engage with the healing properties of marijuana and cannabis, thanks to the law change that has been going through in some states in America. We're going to be here next week in the bunker at Westminster. So we'll, as always, be looking for the facts and the evidence, and looking through some of the media spin to see what's going on in the world. In the meantime, we'd like to wish you all a really nice week, and it's goodbye from us in the bunker. Thank you.
Goodbye, everyone.
Yeah, that just felt like the end of the day.